case briefs, and so much more. LSData's got what you're looking for.
The case of Halbman vs. Lemke, decided by the Wisconsin Supreme Court in 1980, dealt with a pivotal issue of contracts entered into by minors, known in legal terms as the infancy doctrine. Under this doctrine, contracts signed by any individual not yet of legal adult age are voidable upon reaching adulthood, a protective measure designed to shield young people from predatory or unwise contractual agreements. In the spotlight was Halbman, a minor, who had struck a deal with Lemke to purchase a car for the amount of $1,250. Halbman paid an initial sum of $1,000, agreeing to pay the balance in scheduled monthly installments. However, after plowing in $1,100 and encountering a major engine problem with the car, Halbman decided to leverage his minority status, seeking to nullify the contract. Upon returning the vehicle, Halbman demanded the restoration of the monies he had paid. But Lemke balked at the idea of refunding the minor, arguing that he should keep the money to offset the costs of damage that had occurred to the car. This led to a legal challenge that was adjudicated initially by the Court of Appeals, which handed down a ruling in favor of Halbman. The lower court opined that if a minor cancels a contract for a non-essential item, like a car, they are under no obligation to reimburse the seller for any damages incurred prior to the cancellation of the contract. The Wisconsin Supreme Court upheld this ruling after Lemke appealed. The justices agreed that under the infancy doctrine, minors were not obliged to cover use or damage costs after a contract was voided. The ruling emphasized the protective nature of the infancy doctrine, which is intended to guard young people from being taken advantage of by adults in contract cases. Thus, canceling a contract under the doctrine is not conditional on returning the original consideration from the minor. The case underscored the powerful shield offered to minors by the infancy doctrine, reaffirming that a minor's decision to rescind a contract is not tied to the condition of making restitution for any loss or harm sustained by the property prior to rescinding the contract.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.